a license to a learned member of the bar to heap abuses on the judges.
My lord, let us read, my lord.
If that is done, it is browbeating the
My lord,
judges.
therefore I am saying that your lordship, in this light, this is what has happened. We wanted to put this order on record and to show, demonstrate the computation is done without.
Assuming it was,
No,
we'll
I
accept all your facts to be in your favor.
My lord, then
In that event, the only course was that that is why we said in the first available opportunity. All right, let him say sorry, we'll close it. He says, no, I will not say sorry.
With utmost.
No, when senior counsel on his
I
legs,
have asked his permission.
no, Mr. Trivedi, sit down. When senior counsel is on his legs,
sir, I'll take.
don't show disrespect to the senior
My lord,
counsel.
I will ask him and tell your lordship what he wants to convey. My learned friend says that I accepted the rejection. I did not. I tried to press number of times. I'm not saying I did press number of times that your lordship may please be pleased to adjourn. But ultimately, when it was not granted, I accepted it. And your lordship in this light may see the order, which the same bench at subsequent stage passed an order that it may be heard.
Correct. Hearing, that doesn't mean that
Your
we
lordship may
recall
have a
that
look
order.
at that order. Your lordship may have a look at that order. Page 16 of the application.
15/7/2019.
Yes. In view of the substantial compliance of the order of the contempt, we are not inclined to proceed further with the present application filed under the Contempt of Courts Act. However, it will be open for the applicants to take appropriate steps in accordance with law. If any grievance still exists, except the contempt proceedings. Then my lord, the table is given. With the aforesaid, this application stands disposed of. Though the above order was dictated and the matter is disposed of, in view of the substantial compliance of the order under contempt, Mr. B.J. Trivedi, learned counsel for the applicant, continued to make submissions seeking to verify computation. Lord, I was trying to see that it is adjourned by raising his voice. Lord, let me say, Lord, in agitation, a person can say something. No, not bad words, not bad words.
Supreme Court has said in 2 decisions, you can't raise your voice.
My lord, what I am
You
saying
can raise
is,
your decibel, but not your voice.
but please, my lord, my submission is that when a person tries to persuade, it does happen at times. There are individuals and individuals.
Correct. We know.
Some individuals will.
How persuasive Mr. Thakur will be there, how persuasive Mr. Percy Kavina was there,
Lord, but,
Mr. Mihir, Justice Mr. Mihir
Lord,
Joshi.
but each
Oh,
one,
we know.
each one has an individual way of persuading. Sometimes a person tries to
Look at their grace, your grace.
Lord, but sometimes let me put it, lack of grace may not be termed as a contempt. It's a lack of grace. The
Not
two things are
necessarily.
different.
It doesn't stop at grace. It gets promoted to something else.
Your lordship may read, Lord, I am going that to make submission seeking time to verify by raising his voice.
Yes.
And when the court indicated that the matter is already disposed, he started browbeating the court. So there was no browbeating. It was only to seek adjournment.
We will go by this.
Therefore, I am before your lordship. The Supreme Court has said that I can go before the same bench to persuade the same bench.
Yes.
Consistently.
That is why you insisted to have my lord.
Yes, my lord.
We have.
Yes,
I
am conscious of that fact because otherwise the record becomes final. I can only persuade the same bench, and the same bench on 19 September said we'll hear it with the matter. It has said that.
Correct.
My lord,
We are not saying it will not, it has not said so.
So it was not rejected on that day.
Not rejected. Correct. You are right.
Therefore, my humble submission is that the order, Lord, I have 2 submissions to make. First is to recall the order.
If suppose we adjourn a matter, that means petition was not dismissed. Therefore, you allow this petition today.
No.
Not dismissal of the petition means you should allow the petition.
No, not at all. Not at all. I'm not suggesting that. I'm saying that court could have at that very day rejected it, that we don't want to modify. But today I am saying that I want review on two counts. One, the order itself should have been allowed to be placed on record, which now I have placed here, of the Justice Anjaria's order, and then show that the computation which is done is ignoring the 240 days when it was completed, and check that's why the figures were different. Lord, my humble submission is that this order is required to be recalled, and we have not shouted. That is our say.
Nobody is opposing you, correct?
No.
All heard, is heard.
Only, sir, only. If I'm audible.
No,
Give me only one.
no, no,
Show that grace, sir, please.
no, Mr. Trivedi, Mr. Thakur, please tell it.
Fine, leave it.